and I appreciate the courtesy of my colleagues on the other side allowing me to continue my remarks for a few minutes, and I won't take more than 7 or 8 minutes. But my good friend from New York, who just spoke, and he referred to our friendship, and it is a real one. We worked together on a number of things. Talked about the middle class. And I think he's right to talk about the middle class and the effect of the National Labor Relations Board on the middle class. Let me give a little bit different perspective on it. See, my problem with this National Labor Relations Board is that it's not acting like an umpire between employers and employees. It's like acting like an advocate for the unions. It did that with micro-union decision a couple of years ago. It's doing that in this case, where going against the advice of Senator John F. Kennedy in 1959, who said 30 days seemed like a fair time to give employers and employees time to consider whether to have a union election. They're having an ambush, like riding through a canyon. All of a sudden, here comes, people are shooting at you. In just 11 days, you have hundreds of thousands of small businesses across the country who are trying to work, sell their goods, make a living, improve their status. That's the middle class we talk about. And suddenly, they have to go find a labor lawyer, disrupt their business, pay that person money, and every single step they take has to have that sort of legal advice, because within 11 days, they might have an election. There's no need to rush into an election that rapidly. This is a chance to give the union organizers an opportunity to force a union election before the employer even knows what's going on and before the employees know what's going on. Now, if you will, those that it takes up to maybe 30%, I think it is, in order to force the election, but the other 70% might not know. And of course, then you have to start handing over all their personal information to the union. And I don't know, in the modern age, we ought to be more worried about protecting privacy, it would seem to me. But let me give one more example of the assault on the middle class that I see from this National Labor Relations Board and our friends on the other side who line up unanimously with this line of thinking. In every community in America, there are lots of what we call franchisees. These are the men and women who operate health clubs, barbershops, auto parts shops, child care centers, neighborhood restaurants, music stores, cleaning services, much more. These are men and women. We had some who testified before our committee the other day, the Labor Committee. They might have been working for a big corporation. They said, you know, that's not really what I want to do in life. I'd like to run my own business. And so they stop that, and they go out and they become a Ruby Tuesdays franchisee or a KinderCare franchisee or an auto parts franchisee. And they own that business. They run that business. They use that brand name to help it be a success. They use brand names like KinderCare, Planet Fitness, Mary Maids, Panera Bread. They make work 12 hours a day serving customers, meeting a payroll, sweeping up, cleaning the bathrooms. I mean, this is hard work. But 700,000 Americans do it because it's their way up the economic ladder. It's their way to say, I have my own business. I don't work for the big guys. I'm a little guy making my way up. Successful franchisees are one of the most important ways to do that. Yet this National Labor Relations Board, the same one that wants to have ambush elections, has a pending decision that would threaten the very way of life of franchisees. It's called changing the joint employer standard, which since 1984 has required that for a business to be considered a joint employer, it must hold direct control over the terms and conditions of a worker's employment. Basically, through very broad language, the NLRB would saying to that KinderCare or McDonald's or Ruby Tuesdays or maybe AutoZone franchisee, that in truth, you really are part of the major company. And anything you do at your store has to be accepted by the major company. And therefore, If we organize you, we organize it. Well, what's going to happen if that happens? The major companies are going to say, we're not going to take that risk. We're going to own all our stores. So we'll own all the Kinder Cares. The central company will own all the McDonald's stores. It'll own all the Ruby Tuesdays, own all the AutoZones, whatever the franchise is. And what will that do? Well, that might protect the major company because it can hire a lot of labor lawyers. It can instruct its employees what to do and not to do so it doesn't run into problems. But it takes away from these 700,000 franchisees that middle-class opportunity of moving up the economic ladder. That's what this Labor Relations Board is doing. So as we consider this ambush election, which, as I talked about earlier, is nothing more than speeding up the time that it takes between when a pro-union organizers ask an employer for a secret ballot election and when that election actually takes place. They want to move that down to 11 days. Say you've got 5 employees. You're sitting down in Maryville, Tennessee, or Wichita, Kansas. Last thing on your mind is a labor lawyer, and whammo, here comes an election in 11 days, and every single step you take from then on out has to be done perfectly according to the labor law, or else you might have to have a rerun election or be ordered to negotiate with the union. That jeopardizes fairness in our system. Our National Labor Relations Act was to create an environment of balance and fairness among employers and employees. Senator Kennedy said in 1959, and nothing about this has changed in all those years, he said in 1959 that 30 days would be a reasonable amount of time between the time a union organizer files a petition, and the time you have the election. The actual mean time today is 38 days, and 95% of the elections are within 56 days. So what's the rush? What's the problem? Why do we need an ambush? That's the issue before the American people. Senator McConnell and I have another bill to restore the balance in the National Labor Relations Board. It's absolutely fair. It would say 4 Democrats, 4 Republicans. If the general counsel's complaint is outside the law, the aggrieved party can take it to the federal court. If they take longer than a year to decide a case, either party can take it to the federal court. That's fair. That's the kind of umpire that we need in our labor relations today. So this is about the middle class. This is about moving up the economic ladder. This is about the kind of actions that give 700,000 Americans their franchise. This is about the hundreds of thousands of Americans with 4, 5, 6, 10, 15 employees who don't need to be ambushed as they try to earn a living, pay their bills, sweep the floor, make a profit, pay employees, and create the American dream. These are big stakes we're talking about, and we're right to say to this Senate, let's overrule the National Labor Relations Board. Let's hope the House does. Let's hope the President agrees, and we give some sense of fairness and balance back to the relationship between employers and employees in this country. I thank the President. I yield the floor.